We will have as many humans as we will have note takers, if not more note takers. Uh, Spotlight. You know what, Karen? I'm going to put you in the spotlight. How about that?
I will be in the spot. I don't have a ring light. I should have one, but
How do I put you in the spotlight, though? Oh, are you already in the spotlight?
I don't know.
Are you? I have no idea. Oh my gosh. Folks, can you scan? Does Karen appear as like the bigger tile on your screen? Can somebody say yes, no?
No.
No?
No. See, a room full of IT people who are trying to get EB1 and nobody's willing to help me. Why? Help me.
Well, I could do it if it were Zoom, but I know very little about how to run Google Meet.
Neither do I. Like, oh, pin to the screen for everybody. Look at that. Hello.
Yeah.
That
There we go.
bachelor's in computer science finally finally worked. Okay, let's see. Let's say hi to people. Abhishek, Akshay, Angel, Balaji, Bonnie, Gauri Kamath is here. Hari is here. Jitain, Kevin, hi. Mahinder, MG, Prerna Gupta, Priyanjali is here. Sai Krishna, Sanath is here. Sanath, I'm going to put you on mute if we get some background from you. Uttej and Vivek are here. Great stuff. Okay. The annoying thing about Google is that like people will keep coming in and I will have to let them in. I'm like always distracted in the first 3 minutes of the call.
That's okay. I'm probably gonna start, you can launch into my intro at like 7:04, 7:05.
Yep.
But I don't know how this works in Google Meet with muting.
Oh yeah, everybody's gonna be mute.
Okay, good.
The floor, but I will keep getting people in through the door till at the top of the hour that for this call. Where are you right now? Are you in Jersey or are you in New York?
I'm in New York.
You're in New York. I was in the city.
In New York City.
Where, did you say where you were in the? Oh my gosh, is that a security violation? Asking you exactly where you are in New York.
I am not, those of you who are good at geolocation can maybe figure it out, but
did you see the pushback that folks gave to Instagram of setting the default factory setting of like sharing your location with friends and
they're gonna die.
Yeah, it was insane. Like
the number of people at Instagram who didn't have that thought, they all need to be smacked upside the head. That's like ICE not realizing that when they're going around masked up and in, secret agent cosplay, there are going to be copycat criminals and a lot of women are going to get assaulted.
Correct. Did you see, does anybody follow John Oliver? Let's see.
Sometimes, yes. He's very sharp. He's very sensitive to those issues. He's a smart man.
Who follows John Oliver? Nobody follows John Oliver. What are you doing? It's only work and EB1 for everybody on this call. Right? We live, breathe, eat.
Comedy is essential.
Yes. The only thing that gives me hope is I'm assuming that John Oliver got his green card through EB1 as well. And a USCIS officer looked at his portfolio of work and he critiques the US government a lot. A lot. So if he can get his EB1.
I don't know if he can get it through EB1.
Did he not?
I don't know. I mean, I didn't represent him, so I have no idea. He easily could have, but he might just as easily have gotten married.
Correct. That's true too. He did get his O1A. Oh, you know what though? I think so. He did get his O1A. I know Ronnie Cheng got his. He's another comedian.
Oh, I love Ronnie Cheng. He's amazing.
He also got his E1.
All right. 7:04. You gauge it based on head count, but you can launch into the intro whenever you feel we've got enough bodies.
7:05 is when we
Okay.
started. Yeah, I just want to make sure that we're getting folks into the building. But now it's 7:05. All right, folks, welcome. Can I see a show of hands? Do this if you can. Who This is the first EB1 info session that you are attending. Let's see. Angel, Prerna, Ashwini. Well,
Mahendra, Vivek, Suraj.
all these folks,
we got a bunch of people who this is their first one.
And how many folks this is like their third time, not even their second time, but third information session that they're attending, third or more. Okay, Prakhar. Okay. Hi, Priya Anantashankar.
Hari, Akshay, Prakhar. We got a few experienced.
Kevin is also saying that it's like the third. Okay. Kevin, we need to have you as one of the speakers. Kevin is an immigration attorney who are just to catch up to speed. But welcome, everyone. Thanks for joining today. I do want to welcome Karin Wolman, and I don't want to take too much time. I do want you to listen, Karin, what she has to say. I do want to introduce Karin in a way that is befitting to her persona, but and her meritocracy and competence. But I'm going to keep it very short. I will tell you where I met her and why I insisted that we jump on a call soon after. I was attending an information session with a former official from USCIS, and the first person to ask this person a question was Karin. When I tell you I was not this person, but was I feeling sorry for that person, because Karin held his feet to the fire, where she had a point to make and she made it. And that gave me an impression that, okay, here is a lady who is not sugarcoating things, and she will say things as they should be said so that you get the best information, even if it's not the most sweetest information. So that's why I insisted Karin come and talk with you. So Karin is an immigration attorney who has been in the game for a while. She is a Forbes Best Immigration Lawyer in NYC and Best Lawyers in America, New York Immigration Lawyers 2025. So without further ado, I'm going to bring Karin up for folks so that you understand how the flow is going to be. Please keep yourself on mute. Karin is going to be conversing with us from 7:07 right up to 7:27, so 20-ish minutes. Get your pens and papers ready. She's going to deep dive into each criteria of EB1, and she will make you understand that USCIS English is not regular English. So what you consider as memberships, USCIS may not consider as memberships. So she's going to give you that granular clarity together with some commentary around RFE trends and how do you safeguard yourself from those. So that's going to go on from now to 7:27, 7:28, and from 7:28 till the top over 8 p.m. we are going to take your questions. So thank you, Karin, for being with us, and I'm excited to learn from you.
Thank you for having me. It's been quite a journey. I've been practicing employment-based immigration law since the mid-90s, and this is one of the most fun areas of what I do. It's something I really love. I want to help you figure out how to accurately assess your eligibility, with the caveat that no self-assessment is ever going to equal sitting down with an experienced immigration lawyer. It just isn't. A lot of what you see, both in the way of existing big firm prefab questionnaires that are for screening upon initial consultation, and some of the AI-based automated self-assessment tools, what they're really asking you to do as a non-lawyer is to make conclusory legal judgments about the facts of what you have. But I always like to start with the gut feeling and the elevator speech. At its essence, the EB1A asks, what are you famous for? Can you answer that question with a straight face? What are you known for in your field outside of the four walls of your current employer, your past employers, the clients and counterparties who've worked directly with you? What do people who haven't worked directly personally with you know of your work, and how has it affected others in your field? And that's what USCIS wants to know. So I'm just going to dive in and go through the criteria. I'm going to skip the big one, because if you're at the major one-time award, you're probably not on this call. If you have a Nobel Prize, you're not here. So what's a lesser national or international award? Well, for starters, it's awarded to you individually by your name. You have a statue, you have a plaque, you have a certificate. It has your name on it. It has to be awarded by a body that is at a national or international level. How rare or selective is it? You know, did you get to throw your own name in the hat, or did somebody else have to nominate you? How big is the candidate pool? Did the awarding body say what work of yours it was for? Is there a published list of past winners? Who were the judges the year you won it? What are the awarding body's eligibility criteria for consideration for the award? And what are their selection criteria once they've got a pool of candidates for the award? Your primary evidence is going to be a copy of the award certificate or letter or statute that has your name on it, a photo of any 3D trophy or object that isn't a piece of paper, certainly a copy of anything that came with it. If there's money that comes with it, keep a photocopy of the check, the gift card, the whatever. If there's some cash value non-monetary thing that comes with it, like a residency or a month's use of a lab with a lot of equipment, you want to document that and keep that as part of the record of you winning that award. You want, in addition to proof that you won it, you need to have the secondary evidence from the awarding body, preferably what's published and on their website, that says how frequent the award is, who gets it, what are the criteria they're looking for, what's the size of the candidate pool, is there a list of past winners, is there a list of this year's judges? But most importantly, you want something, and you may have to get it separately in a letter, that says, what did you win it for? And I am trying to document that for myself for two things of relatively recent vintage, where I reached out to people from the awarding body and said, could you write a letter? Because I don't know what I got this for. Criteria number 2, memberships. This one is really straightforward. Paid to join societies don't count. If all you have to do is work in a particular field or have 5 years work experience or pay the fee, then it does not meet the regulatory criterion. They're looking for your membership in associations that demand outstanding achievement. They're looking for something where you have to be nominated, where there's peer review, maybe you have to present a portfolio. Who's eligible to join? What are the admissions criteria, and who judges those submissions? So if you have such a thing, your evidence is going to be both your membership card, your invitation letter, your dues statement, plus whatever there is on the organization's website or in their handbook that says what you have to do to be admitted to membership and why that displays distinction. Published material about you or your work, what I like to shorthand as press. This is an assortment of things. It can be press coverage about you. It can be editorials in trade publications or business journals. It can be interviews with you. And if you're in a scholarly or scientific discipline, it can be review articles by either the journal's editorial staff or others in your field about your published work. But it has to either mention you by name or mention your work. Every such article, you need to show the name and date of publication, the title, the full text of the article, with the byline if there's an author or authors, with the URL if it's printed from an online source. If the original is in a foreign language, you need a complete English translation. Before the advent of pretty good AI translation, you needed to have a sworn translation by a translator who was not you and not related to you, but you can probably get away with an AI translation as long as you disclose that that's how you got there. But you do need to submit any foreign press article with its complete English translation, which should also show the name and date of the periodical, the date of publication, the title of the article, the author's byline, the full text. You're also going to want, for anything that has an online source, you're going to want its media kit, its audience demographics. If it's a scholarly or scientific journal, you're going to want its impact factor. And if you have any testimonial letters, please don't call them references. They're not character references. But if you are getting peer expert letters for your case, you want one or two of them to discuss the importance or level of influence of those publications. What are the most important, most respected publications of record in your specialty? Who are the people, who are the important people in your field who are in that audience demographic, who read that religiously? That's an important bit of content to get into the record. Criterion number 4, judge of the work of others. This one gets under my skin because I am in the middle of answering an RFE where, as is their wont, the government just lied. And they said, the record has lots of invitations, but there's no evidence that you complete any of these reviews. And that was false. There was evidence that the individual in question had completed at least 16 peer reviews of articles authored by others. And I am taking them to task for that in the RFE response, where I am essentially reading aloud to them from the record. That is an increasing trend that we are seeing these days, where USCIS, instead of addressing what's in the record and saying what's wrong with it, they simply claim it's not there, which means they have no counter argument. And it's not clear whether that's time pressure or laziness or, using AI to skim it. But they're not real good at understanding what facts are actually proven in the record. And we're seeing that a lot. So I'll come back to this in packaging, but list everything you include and double, triple, quadruple check before you file that your table of contents and that your exhibit list are accurate. Again, I am currently working on a case where there was an index of exhibits, but it had some errors, and it claimed some things were in there that are not in there, and it claimed some things weren't in there that are in there. So you want to make sure that you are accurately cataloging each and every item that is included in your completed petition package before you send it out. Obviously, keep a complete scan that has every single thing in the order you presented it. But when we're trying to prove judge of the work of others, you want, at the very least, the invitation to review something and the thank you note or the conference or journal's website with your login showing reviews completed. You do need to document that you've completed them. Criterion 5, original contributions of major significance. This one is so variable because it really depends on what your field is and what kind of evidence you have. And it's going to vary so widely from one case to the next that it's hard to give specifics on this one. But different attorneys have different feelings about what are the most non-negotiable, most essential criteria, I think this one is the non-negotiable. I think original contributions of significance in the field is the criterion that says, this is why I am doing something in my field that my colleagues would miss if I weren't here. I am impacting other people's work in a specific way, and it matters. What is going to constitute primary evidence of that is going to vary so widely depending on what you do that I can't comment on it in a generalized way. And I've seen good screening tools from people who hyper specialize, like people who only work with tech founders who have, you know, funding and patents and very specific innovation-based achievements. I do more than that. I do all different kinds of EB1A, everything from fly fishermen to company founders and dancers and fine artists and performing artists and graphic artists. One of the joys of going solo for me was I can handle cases for people in any field of endeavor at all. And that is one of the things that keeps it interesting. Scholarly articles in the field. This one doesn't actually just mean journal articles. It sounds like it does, but if you read the regulation carefully, it is not limited to scholarly journals. It includes trade publications and general major media. In other words, things that don't have footnotes, headnotes, indexes, bibliography, because their formatting and their editorial standards don't go in that direction. A work is scholarly by virtue of its content and its intended audience, not its formatting. That said, I had somebody come to me for a consultation within the last couple of days who claimed he had authored lots of scholarly publications. And then I scratched the surface and it turned out that they were self-published blogs. No, no, no. If you published it yourself, that doesn't count. If you are a blogger, an influencer, an online personality, you can use self-published material to show commercial success and to show that you have a following. By all means, show your numbers of followers and your paid subscribers and your unique views per month, but don't call it authorship of scholarly articles, because self-published material is absolutely not going to fly under that banner. And with scholarly publications that are from journals, academic or scientific, don't just submit the abstract. You need full reprints or preprints of the whole thing. And you may want to have some secondary evidence, including editorial standards and the impact factor of the journal. Yes, conference papers as well. I tend to include conference papers in the same bucket as journals. It's the exact same thing. It entails peer review. You need a complete reprint. Show what the editorial standards were, and include authorized reprints.
Karin, could you tell us why you discourage folks from just printing the abstract or the first page? Because, like you said, there is a fair amount of variation in the advice that attorneys will give their clients. There have been advices where for the content of the entire petition, just submit the first page, it's okay. Why do you insist on the entire thing?
It depends how many you have. But even if you have hundreds, you're obviously not going to submit all of them. You want to submit full reprints of a handful of your most influential articles. And then maybe you can include just the first page of a few more. But I have seen explicitly USCIS pushback and rejection when only abstracts are provided. And they will say, well, you didn't provide your publications. So at the very least, you want the first full page from a reprint. And I would recommend having full text of at least a handful of your most impactful, most widely read articles. Because if you don't have any full article copies, they will come back at you and say, you didn't give them to us. Technical blogs on your employer's website are not scholarly publications. That's a self-interested publication by your own employer. It's not that it's not published, and you can include it, but it's not going to be viewed as having the same weight as something that was reviewed at arm's length by a conference or a peer-refereed publication, because you're working for them. You are advancing your employer's interests. That is what you're there to do. Display at exhibitions or showcases, don't try this with poster presentations. It is formally limited to solo or group shows in the fine arts, and USCIS has interpreted it that way. I'll get to the questions later, but things that don't have formal reprints are not going to pass muster as being at the same level of scholarly importance. Leading or critical role for organizations or establishments with a distinguished reputation. This is the one, the criterion 8 is the one that you lean on when there are awards to the company or to a team or to a project or a thing, where the award is not won by an individual or even by people, but by a company or a thing you produced. Then you want to go with criterion 8 and explain the basis for the award, the thing that won the award, and then document your critical role in producing the thing that won the award. And that'll be multiple pieces of evidence for each thing. You're going to have to tie it together. Criterion 8 is very much a connecting the dots exercise. But it requires proof both that the organization or establishment is distinguished and proof that your role in that thing was and is leading or critical. Here's one I see abused a lot: high compensation in relation to others in the field. This one is strictly quantitative. If you are not in the 95th percentile or above for your occupation, don't even bother. You need actual proof of what you've been paid and will be paid. W-2s, 1099s, tax return transcript, employer contract or offer letter. And then as proof of what is the norm, you're going to need multiple salary surveys. One is never enough. Don't just go with what comes from the Labor Department. Look at Indeed and Salary.com and half a dozen others. Maybe you want to get a letter from a headhunter who has experience specific to your sector and who knows what the top people in your specialty make. And they can say, yeah, this person's really in the top 1% to 2%. But I saw a petition recently where the attorney who initially packaged it had argued high compensation, and had left the portion of the form I-140 blank that asks for the standard occupational classification and what the attorney does. And that's just laziness. That's passing up an opportunity for advocacy. And criterion 10, again, is limited to the performing arts on its own terms. It's commercial success in the performing arts, and that's ticket sales, streaming revenue, followers, paid subscribers. Don't try to use that outside the arts. It's not going to fly very well. There is a comparable evidence criterion. You're not going to get EB1 if you're relying on comparable evidence to hit 3. Use it as a 4th or 5th criterion, but not as a 2nd or 3rd. If you're relying on comparable as the 2nd or 3rd, you don't have a strong case. In terms of how to classify your evidence, once you've marshaled everything you think you have, go to the USCIS online policy manual. It is free, it is publicly available, they update it all the time, and it is very, very detailed. Learn the difference between cataloging your achievements and making a self-interested statement versus proving them. You know, your CV, your resume, your publications list, those are self-interested statements. They're not proof of any of those things. Those are just an index of things you say you've done. You will need arm's length objective evidence to prove that you have done those things. And USCIS can be quite touchy and difficult about proving those things. Packaging. You want to hone your elevator pitch. You need a pithy, short, compelling elevator speech, a little summary of why what you do is important to others in your field. What have you done that other people have built off of that is in use outside your own employer? You know, have you published work that other people are doing new original research based on it? Did you develop a practice that is now a benchmark that everybody else in your industry is using or they're about to? Did you change the way something is done that other people have followed suit? You need to think about how you encapsulate why your work is important to the field. You want to organize stuff in terms of the primary evidence for a criterion matched with the secondary evidence for that criterion, and then say, I've proven that by more than a preponderance of the evidence, and then move on to the next one. And, you know, as I was saying before when going through each of the criteria, like you want your award certificates to be matched with the photo of the statue, the photo of the check you got, the awarding entity's website listing who the judges were the year you got it, the letter from them saying what you got it for, you know, your organization membership card along with the published criteria for admission and maybe a letter from the membership director welcoming you or whatever. Here's a really elementary one that I see experienced attorneys tripping up on all the time. Every expert letter comes with a separate document. Never mind the intro in paragraph 1. All expert letters come with a CV, resume, or their professional bio as it appears on a company website, a university website, their own website, whatever, but you want their full bio. LinkedIn resume is a watered down, deep second choice. It's better than nothing, and I've seen cases that were filed with nothing. If you don't want USCIS to read any of the letters, then yeah, don't submit any bios for the writers, but they won't read them if you don't. I'm serious about the secondary evidence. If you don't give them any, they won't read the primary evidence. This should go without saying, but apparently not. Expert letters should be on their professional letterhead. Where you are dealing with people in sensitive federal agencies where there may be policy prohibiting them from writing on letterhead, ask them if they have other letterhead. Very often people who work for federal agencies may have a private consulting company on the outside. No, I'm going to interrupt myself here, but no, the bio is a separate document. They can introduce themselves in the letter, but they need to attach a full CV. And the letter should be mostly about you, not about them. Otherwise, it's not very flattering to you.
I'm keeping an eye on the time, Karin. Do you think we'll be able to launch it?
I'll be done in like 5 seconds.
Awesome.
Yeah, and obviously for all scholarly and regular press articles, whether by you or about you, not cropped, show the URL, show the periodical name, show the issue and the date and the page numbers, the author, the full text, everything. You know, and summarize which criteria are met and why your work is important to others in the field outside of your own employer, your own company, and its clients. What is the impact your work has had and is going to have on those in the field who aren't working with you directly? Now we can go to questions.
All right, folks, I know you have a whole bunch of questions. For people who have put their questions in the chat, you're welcome to raise your hands. We are going to go through the list. This is the button that you select to raise your hand. So please go ahead and raise your hands. I can see Rahma and then Suraj, Mansuk.
Okay, Rahma, what's your question?
1 second. Before we launch into questions, some housekeeping. Please keep your questions to 1 per person. That means no elaborate questions. That means no question part A, part B, no follow-ups, nothing. We just want to make sure that everybody gets an opportunity to get their questions answered. No question is stupid, no question is small. Sometimes the most basic questions will lead to the most insightful conversation. So please don't shut you in. Can we go till 8:07 so that people?
Absolutely, I can run over.
Okay, perfect. All right, Rama, go for it. 1 question per person.
Hi, Karin, and hi, Aditi. Thank you so much for that webinar. That was really interesting. My question, so when would be the best time to consult an attorney? So after we think we have a strong case, or as we're building that out, can we still consult someone?
The time to consult with an attorney is before you're ready to file. It's better to wait until you've assembled your documents. I'm sensitive to this because I'm sort of going through it myself somewhere else right now. But what an attorney wants to see is the arm's length evidence, not your summary of why you think you qualify.
Okay. Thank you.
Hopefully that helps.
It's like,
it does.
I see like attorneys are like chefs. They want to see your ingredients so they can figure out a good dish.
Yeah.
Yeah, so you need to show.
We want to see the mise en place. We want to see your ingredients, your seasonings, your dry spices, your fresh herbs. Like, what are we working with here?
Correct. So that they can think expansively, because your attorney's ability to defend you will live and die on the hill of what proofs can you gather. That's what
you haven't told us. This is the thing I put in my engagement letter because it's so important. Your attorney cannot protect you from the consequences of things in your past history that you don't tell them about. Your attorney is not the government, so you should err on the side of telling them more, not less.
Oh, absolutely. Absolutely. Treat your attorney as a therapist. Tell them all your deep, dark secrets.
And make sure that your attorney is somebody who gets you. As I said during our introductory call when Aditi and I were getting acquainted, we are porters of stories. We're not allowed to write fiction, but I can't carry your story whole to the right place if I don't understand your vision of the right place.
Yeah.
Well, make sure your attorney is somebody who really gets you and understands where you want to get to.
Yeah.
Make sure you're clear about your career trajectory and what your goals are.
Suraj, go for it.
Hi, thanks for this. I have a question about the membership. So when you were explaining what all do we need to say when we are a member of an organization, you talked about who is eligible to join, what is the criteria of joining, and who judges it. Can you expand on that a bit more?
Pay to join societies don't count, full stop. If it's not something like AAAS or, if it's not a distinguished organization where some peer review has to happen for you to get in, then don't use it.
Is that that's how it is for most of the organizations, but then how do we show that side of the story to the USCIS officer? I mean, we just give them the bylaws and that's it?
Yeah. If it's clear from the entity's classes of membership and what you have to do to get there, if all you have to do is be somebody who works in the field 4 or 5 years or 10 years and pay a fee, that's not going to pass muster. On the other hand, if in order to be admitted to a society, you have to be nominated or provide a portfolio of material for them to judge, then use that information from the organization's website or its handbook to explain that this is something. No, Startup Accelerator isn't a membership. That might be a leading and critical role. It might be an award, depending on how you get there. Incubators are, they're more award-like than membership-like.
I want to throw this because people are talking about this, and Karin, you can correct me if I'm wrong, because, and is anybody not from India over here? Not from India.
Well, Kevin, not from India, but
Kevin, we are claiming you as our own. You are from India from now on. But there was a reason why I mentioned that we are from. Yeah,
Rama Diallo is not.
The cultural training that we get when we are from India, and this is something that I have learned myself and had to unlearn as a professor, is we were never asked to question authority. So if something is from the government and if it's written on paper, then we are like, okay, now we have to roll with it. But speaking to attorneys like Karin, as well as one of her mentees, Senya, I have realized that even if something is written in a way which looks legitimate in an RFE, that does not mean that it is in fact true.
Oh, the government lies all the time here.
So you have to,
are full of nonsense. They misstate what the legal standards are. They make stuff up.
Yeah.
They lie about the facts in the record. There's an old article that I use for my own goalposts, and I still refer to it myself. It's from 2015, so it's a decade old, but it's on my website on the articles page. And it's called How to Handle RFEs for the Extraordinary Worker. And one of my co-authors made me take this out. But in the first step, I had something about, when you first get it, scream, run around the block, stand on your head, do whatever you need to do to let the steam out, because your first reading is going to piss you off. Because you're going to say, didn't they read anything? And unfortunately, the answer may be not so much.
Mm-hmm. Yeah. The reason why I brought that up is because for memberships, what I have seen, and Karin, you can correct me, this is one membership that is cited in RFEs that, hey, this membership, you have to give me XYZ, and they will always cite, or not always, they have cited National Academy of Sciences. So if you go under membership, you will see that, oh, it's a widely accepted mark of excellence. It's like, these are the types of.
Yes, or the National Academy, those are clearly things that do require outstanding achievement.
Correct.
The gray area where you may have some wiggle room is some pay-to-join societies have higher, more advanced levels of membership that you only get invited to once you've demonstrated significant contributions to the field. But again, you have to document it. You have to prove that the level of membership you have wasn't just, I paid them some money and they let me in.
And they got me in. Yep. Mansukh Sen.
Yeah, like IEEE senior membership. You have to pay the fee, but you also, there's a peer review process. You need to get letters from your peers. Some other societies, you may have to present a portfolio of work. But yeah, anything that involves a peer review process or nomination and submission is going to be at the level that they're thinking of, but you have to document that there is such a process to get in at that level.
Yep.
Perfect. Thank you so much, Karin, for your time today. I have a quick question about original contribution. So can you give me an example of what would qualify as an original business-related contribution of major significance to one's field, please?
Well, a business contribution of significance might be something that is now accepted as best practice that you introduced, that something was previously done a different way by everybody in the field, and you introduced a new technique or methodology that is now standard. Or, you know, a previous medical procedure was really high risk and you invented a device that, you know, reduced mortality by 90%, or you have a patent that has been commercialized and is in use not just at your company, but is now being adopted by others in the field.
Got it. Makes sense. Thank you so much.
There are lots of different ways for something to be an original contribution of significance, but it depends a lot on how you work and what you do. If you are in the research sciences, then you want a high H index and not just reprints of your own articles and not just a citation list. Then you'll want full reprints of articles by others showing the substantive work of others who are discussing, quoting, and building upon your research to further their own research.
I did a workshop with Rohit Srinivasa just on this topic of original contributions of major significance. I put the YouTube link in the chat. I'm going to sound like a YouTuber. Please subscribe to my channel, and you will see those videos. And it's a treasure trove of information. So I hope that you watch it, even though it's long. But you're going to get some insights from there. It could append what Karin is saying on this call.
Somebody in the comments a moment ago mentioned the CFA. I would posit that CFA is a credential that requires significant achievement. It's a hard exam. It does not have a particularly high pass rate. They rescheduled it a bunch during the pandemic, which was particularly trying for several years worth of candidates. But, you know, they say business school is a mile wide and an inch deep, and the CFA is an inch wide and a mile deep. It's hard to get. So that's a credential worth mentioning. And you may want to characterize it as a membership or a license, but it's certainly something that takes effort to get.
Yep. Hari.
Thank you, Karin, for the session, and Aditi for organizing this. So I know you went through all the criteria, but nowadays I'm hearing even if you meet the criteria, you need to meet the sustained acclaim and the final merit determination to fully qualify.
Is a black box. We're not going to get in Schrodinger's cat land, because final merits is, even among lawyers, that's an hour's discussion and it goes around in circles. But as I said, I think the most important criterion is, what are your original contributions of significance in the field? Can you identify something you've done that other people outside of your current and former employers rely on? What has driven change or moved the field forward in some way that was an innovation of yours?
You have given me a brilliant idea. I have like 7 attorneys back to back in September. We are going to have sessions every weekend in September. So we want to join. I want to do a workshop on final merits. Like, what the hell is this? What do we do? How do we cross this barrier? So you've given me a good idea. I'm like, okay, I'm going to do it.
It is a black box. Final merits is a sniff test, and it was basically a weird misreading of what happened in Kazarian, and the government has used it in a really backwards way. We're not going to discuss each and every membership under the sun. That's a waste of time. I think I've said enough about memberships. But
should we bring the next person up?
Yeah.
Mahinder.
Thank you, Karen, and thank you, Ati. My question is regarding the citations for patents or scholarly articles. What is the number? Is there
there isn't a number.
Okay.
This isn't about quantitative. This isn't about counting. This is about how important is it.
Okay.
If you have a patent, if you have 3 patents, but no one is using them, then it doesn't really matter. But if you have 1 patent and Northrop Grumman is using it, then that matters.
It is.
It's about scale.
There is this, oh my gosh, can I not? Oh goodness. I wish I could share my screen to show you something, but then I don't want to reveal the person's identity. But I was reviewing an NOID, and this is what USCIS says. Truth is to be determined not by the quantity of evidence alone, but by its quality. Thus, in adjudicating the application pursuant to the preponderance of the evidence standard, the director must examine each piece of evidence for relevance, probative value, and credibility, both individually and within the context of the totality of evidence, to determine whether the fact to be proven is probably true.
Yeah. And you can win a case on, will a citation that is patent pending? I'm sorry, I didn't even understand the question.
Let's go through the questions like for folks who have raised their hands so that they get a fair shot.
Yeah.
Then if we have time, we'll come back to the comments. Brucker, go for it.
Yeah, a great question. Thank you so much for doing this. My question is about, I know we don't want to talk about final merits, but I just want to confirm the rule of the law. I think what I've heard is that sometimes there are petitions that are rejected because the officer has reviewed the individual criteria on its own merit in terms of sustain a claim. But at times I'm hearing that it's the combination that is supposed to be looked at. Are both of those things true? Or is one of those things?
What the officer is supposed to do is review the evidence in the record, and they are required to review all the evidence you submit. And my RFE responses are getting increasingly tartly worded because the government is waving its hands and saying, no evidence was submitted under this criterion. What about exhibits 15, 16, 17, 21, 23, and 39, which were all relevant to this point? So they are ignoring evidence in the record that does prove that you meet that criterion, but then separately, they also have to do a review at the end. Now, I wrote a practice pointer for ILA a couple of years ago, but I think it's up on my website. I forget.
You want to tell what ILA is for folks here?
Oh, it's the American Immigration Lawyers Association, my professional association of record, and sort of an essential practice tool for lawyers. But officers, what's their motivation to ignore the evidence? They only have 10 or 15 minutes per petition. They are judged on productivity, and they don't spend very much time on each case. And so they are, in some situations, according a very cursory level of review to something that requires much more attention. And they're denying that evidence is there. That's definitely there.
Don't you love it? Like, you're putting in so much effort to show sustained acclaim, years of work, only to be assessed on 10 minutes.
Yeah. And in terms of the worry about sustained acclaim, what you want to worry about is where the bulk of your evidence is 6, 7, 8, 10 years old and you have no recent achievements. That is problematic. They want to see that you have sustained the level of acclaim that really shows that you meet what the criteria is about. I'm not going to keep addressing every comment that pops up.
Yeah, you can. We can. I'll just go through the list. So you can. We have to ignore the chat, unfortunately, because we want to give folks who have raised their hand a chance. Angel.
Hi. Thanks for doing this. It's very informative. And also, this is my first session. I have a basic question. How many criteria do we have to meet, like the minimum number of criteria?
The minimum is 3, but one of the things that they are doing when they don't like your elevator pitch and they just don't see the importance of what you do is they'll say, well, you met 3 criteria, but on the final merits, we're not loving it. And it's a sniff test. It's a black box that you can't look past it. It's kind of like consular non-reviewability, but for USCIS, they can go, nah, we didn't like it.
Yeah.
So, I would say it depends. The minimum number really depends on the strength of what you have. How big is it?
Would you say, like, I analyzed, if folks want to grab this, I don't know if you have grabbed this or not, but I'm not a lawyer, but 43 EB1 approved cases, the people behind them gave me, what their profiles look like, and I analyzed the data, and I looked at those trends, and it looks like 4 to 5 is the sweet spot that you want to.
Yeah, you want 4 to 5 is a solid case.
Yeah, 4 to 5, and it depends from profession to profession what those 4 to 5 criteria are. But for industry professionals, for all, like, what the data is saying is it's critical role, original contributions, or salary to support critical role is the trend, and then judging and authorship and comparable evidence for exhibits through talks. So those are the criteria that folks most likely go for in successful cases. But again, realize these are 43 cases. There are 25,000 cases that were submitted and 16,000 approved last year. So you do not want to make your decision based on a small little thing. That's why you need to talk to as many people and go to as many lawyer sessions as possible. Preeti.
Thank you.
Hey, I think you might have in a way answer this, but I'm still going to shoot. So it's actually for scholarly articles. Let's say we are publishing a paper that is on a well-established journal that needs to be peer reviewed and all that. So does that paper count as is, or having more citation on it makes it a better paper? Or does
obviously the more citations a paper has, the more important it is to the field. Which is why papers that have been published at the time of filing are inherently more valuable than papers that were accepted for publication but are still in press at the time the petition is filed. You want to show that your published work that others are reading is influencing your field, and the degree to which something is cited and others are using it as a jumping off point for their own research is a marker of how influential your work is.
Lakshman.
A quick question. So I have a patent I have just recently submitted, and it is in submitted stage rather than approved. But this patent has been used by a company for more than 6 months. We are like collaborating with them to improve it. We are not getting any monetary benefit out of it. So can this be a solid evidence?
Well, you certainly want to, you want to submit evidence that it is being commercially used. You probably don't want to file your case until the paper is at least accepted, which means going through whatever level of peer review they're engaged in.
Yeah, this is a patent. Yeah, it is submitted stage already.
Submitted, but has it been accepted? Has it passed peer review, or do you have comments and revisions in play?
Yeah, that stages are yet to be passed. Yes.
I would wait until it's past the reviewer's comments and that you have a final version that's accepted by the journal.
Okay, this is a patent. Yeah, this is with USPTO, US organization. Okay.
Okay.
Yeah.
Yeah, you want to wait until the patent is accepted.
Okay,
See,
thank you.
folks who have stuck around till 8 p.m., are you ready for like something that I have noticed, which I have done as well? This is not like coming from a holier than thou perspective. I'm like, oh my gosh, look how perfect I was. No. Most of the heartburn that you will experience, or these indecisions that you're going to experience, will come from you citing things that you wish would get by, that you wish would be enough. That, for example, when I went for my EB1, my book was accepted by a publisher, and I thought that the acceptance of that book was enough. Like, will this go? Will this go? And my lawyer was like, no. I mean, you have to wait for the book to come out and for people to read. All the frustration, or 99% of the frustration that you feel, or the indecision that you feel, will go away with time.
Yeah. And patience, she's right. Patience, you submit when your evidence is ripe. And being impatient and wanting to submit with things that aren't ripe yet will only get you in trouble and cause you more heartburn later.
Completely. And please, and this is again me speaking to my past self, who insisted on doing this, and this was the worst thing that I could have done to myself, is citing somebody else who got by with a non-ripe profile, hoping that if they could get by, why can't I?
Well, for one thing, adjudication standards have tightened up. And the last couple of years, there were an awful lot of people throwing a lot of spaghetti at the wall, and some of it stuck.
Yeah. So please don't take that as a barometer. I hated my lawyer. I will be honest with you. She was the devil in my eyes. I'm like, why are you squashing my dreams? But now when I look back, I am so thankful. I'm so thankful for the advice that she gave. It's not the advice that I wanted, but it's the advice that I needed. And because of that 9 months that she made me wait, by the time my petition was filed, I got tenure as a professor, and all the evidences that I submitted as tenure went into my petition, to the point where I would have been freaking surprised if USCIS gave me a no. Because how can you give me a no when 25 other professors?
But that is a perfect analogy, because a tenure package is very similar to an EB1 package.
Completely similar.
It's the same kind of things.
Yeah.
Your department chair wants to know what's the value? What are you bringing us?
Yeah. It was honestly, in retrospect, the time that I had to put in was the biggest blessing that happened to me in EB1. So like, if this conversation has given you that perspective that, hey, you know what, everything is going to be fine if only we give it time and do the work, it's going to happen. But please don't frustrate yourself trying to wrangle this out in like 6 months. No. Kevin. He's gone. Kevin is like, I'm done.
Failed on us.
Kevin is like, I can't take this anymore.
Okay. Can you hear me?
Yes.
All right. Hey, thanks, you guys. I love the clarity. This is the thing, you know, we float around so much and we get so much noise, but this has been really, really helpful, even for those of us that have been in this a little while. I have kind of a serious question about what you were saying about responding to an RFE. It's more like a lawyerly thing. I've always been very circumspect in my RFE responses, stick to the facts, stick to answering what they've said. But what if they have really just dropped the ball and not even looked at your submitted evidence, or they're like missing?
I read them the Riot Act, and this is you may or may not have seen any presentations that involve me and James. James Wallace and I, we have kind of a running joke about this. James is team honey. He's nice until you force him not to be. I am team hollowed out cadaver.
Good cop, bad cop.
Nice when I am dealing with a government official who's not doing their job. When I get a sad ISO who's confused and says, point me in the right direction, I don't understand what this person does, then I can be really patient with them. Yeah. And I explain what the field is and what this person does and why A connects to B. But my respect goes out the window when I'm dealing with an immigration services officer who's lazy and not doing their job and lying.
Yeah, that's great. And I mean, I guess the thing is, I'm always concerned. I don't want to do anything that's going to hurt the client, right? But I guess, and what I'm getting from you is that they deal with this.
Sometimes you have to bitch slap the officer to get them to wake up and realize, oh, we really didn't do a whole bunch here.
Yeah.
I have
going to be on YouTube. Just
I have a line that I have used in more than one RFE response, where one of their hack tricks that they've been doing for years, and actually decades, they've been doing this since the hockey cases in 1995. They love to just kind of wave their hands and say, no, there is no real press about you. None of this press counts. And their current iteration of that is, well, this is all press from the internet, which isn't real. And I have a thing that I do, which is, you sound like a Luddite grandpa who's throwing his shoe and yelling at the television. Are you not aware that all publications in every news media have bigger circulation and readership online than they do in print in 2025? Hello. Yeah. You have to make them understand how ridiculous they sound.
Yeah, great. Yeah, and that's really advocating for the client in that situation. Yeah.
All right, we have 3 more people.
Tell me the New York Times isn't real because this is an internet printout.
Yeah. All right. Thanks.
All right, Sumaya, who is SSGG? What's your name, my friend?
Hi, I'm Shiv.
Hi, Shiv. Okay, so it's Sumaya, Shiv, and Jitain, and then we'll call it a day. Sumaya, go for it. 1 question per person.
Thank you so much, Karin, for such an insightful session. And I really appreciate, Aditi, you doing it. It's really helpful. I have 2 questions. I'll quickly ask them in interest of time. My first question is, if somebody is in industry for 15 plus years and have a progressive career as well, but still they don't want to claim the critical role or high salary criteria because of the first fact that they're based out of the US and are in a very different market where salaries are very different. And then second, for some, internal company reasons, and they are not PhD, but they have 12 plus research papers published in high impact peer reviewed journals, and they are highly cited. So can they claim original contribution through those publications?
Maybe. And that's all I'll give you is maybe. I would need to see them and understand what the impact is.
Correct. Yeah, we need more context.
Yeah, that by itself doesn't convince me.
Yeah. And that is also, folks, that is also the sign of somebody who's thinking critically about your profile. As much as it feels nice to get an instant answer, the answer, a good one, is never instant. Your question should be followed by 5 other questions. And if that other person is not asking you 5 other questions, then the answer is not right.
Okay, thank you. I will quickly ask the other question.
Don't trust a law firm where their entire consultation is 15 minutes. That is not enough time to do a deep dive and assess what you really have.
Yeah.
Sure, that makes a lot of sense.
Maya, we have to move on to other people. If everybody's getting one question, we need to keep it standardized, okay?
Sure.
Shiv, go for it.
Hi, so my question was about the final merits. I believe totality and final merit is the same thing. If not,
Yeah.
Okay. So once they judge on that and they decide that, okay, the criteria are met, but we are not happy with the final merit / totality, is it very explicit in their
Usually it's explicit. They'll tell you, well, we think you met these 3 or 4 criteria, but we're not giving you final merits because we don't see that what you're doing is important.
And would they give us a chance to rebut that?
Usually you will get an RFE that says, we'll give you this criterion and this criterion and this criterion, but we think you fail on final merits. And usually there will be an RFE and they will explain why. But you can very often tell from the tone, the way an RFE is written, whether you're going to survive or not. Sometimes you can smell the denial in the offing.
Got it. But you do get a chance.
Usually you get a chance.
Okay, got it. Thank you. That's all.
You know you're not getting a chance when it's annoyed, not an RFE, and they only give you 30 days.
Gotcha. Thank you.
Jitain, you're the last one, my friend. Make it a good one.
Yeah, thank you. Thank you, both of you. Really helpful. So I have a question about critical role letter of recommendation. Like, how important are the numbers on the letter? Like, how big the numbers?
You mean
should
the
be?
numbers?
Numbers mean like $1 million.
No. First of all,
90.
they're not recommendations. I have to explain this to people writing them at least every other week. It is not a recommendation. It is not a pat on the head. It is not a character reference. USCIS doesn't care whether you're a good person. They don't want to have dinner with you. They want to know if your work is considered important by other people in your field. These are expert testimonial letters, and think of it as testimony. If you had this person sitting down live in a courtroom in front of USCIS, what would you want them to tell the officer?
Okay, sounds good. And how long, like how back we can go to get the critical role letter? Like 15 years back is okay?
You want more people who know what you're doing now than people who knew you were when you were knee-high to a grasshopper. Letters that all come from people who were your academic advisors and former employers is kind of sad, because that indicates that you are not making a big impact on your current peers in the industry.
Yep. I was looking for, man, she wrote a really good post on LinkedIn. Oh, there you go, I found it. There you go. Oh my gosh, wait, hold on. I must share this with you. So it's by immigration attorney Ariana Escotiu. Prerna, happy to chat. Just reach out to me over my LinkedIn DMs. We'll talk. And she writes this, that it's an EB1A NIW letter of recommendation tip. She says the term letters of recommendation is a misnomer. Now I understand why we think letters. I have my own hypothesis, and I'm just going to talk about this for like 2 minutes, because and again, folks, if you have these questions, I never want you to feel small. That, oh my gosh, it's common knowledge. How could I have asked this question? Because trust that I have asked worse questions. Because EB1 is such a black box. You're trying to make sense of something with the existing knowledge that you have. So the existing knowledge that you have is, you know that when you came to the US, you needed letters. If you were coming to grad school, you needed letters. So when you hear on the streets that you need letters for EB1, you latch on to that. That's where you need to pause and understand that the letters in EB1 is not the same as the letters in a grad school application, even though it's
not the same as letters for perm. For perm, you just need letters confirming he worked here from date X to date Y in these job titles, worked on these kinds of projects using these kinds of tools. So a work experience letter, which is what you need for perm, is completely different than an expert testimonial that you need for an NIW or EB1. And don't use templates. Every draft should be different. It should be tailored to what that person knows of your work and how they've worked with you and how they know of your work and what their expertise is and their perspective on the field.
Yep. 8:15. Oh my gosh, I've kept you for too long, Karin, because you joined at 6:50. Folks, can we have a round of applause for Karin? She has been extremely generous with her time. There are many immigration attorneys, but only a few agree to come to these talks. They are not obligated to come here. So I really hope this is something that I wish I had when I was going for my EB1. The only source of truth that I had was my lawyer, who was burnt out, and I didn't know who else to go to. So it gives me great joy to bring folks like Karin to you. So please make sure that you give us kind testimonial to Karin. If you want to talk with Karin, she has put her information in there, KW Karin Wolman visa.com, I think.
KW Visa Law.
KWVisaLaw.com. For Karin, any last words of advice for people who they are literally the last men and women standing? So what special words of advice would you give them for folks who stayed till the very end?
Thank you. Thank you for hanging out with us and listening and thinking carefully about how to tell the story of your future.
Yeah, I hope it's a really good story. It has to be a really good nonfiction story.
It has to be nonfiction. I always tell clients, I can pick out window treatments and paint colors and, draperies, but you got to give me a foundation to hang the house on.
Give that foundation to them. They're going to create a good meal for you. So thank you again, Karin, folks. Thank you for joining. Keep an eye out for future emails from me to know when the next attorney is coming. It's going to be, and if you have any requests, like for example, today I got a really good idea about like final merits determination and possibly letters as well. So if you have any requests that Aditi, I would really like a workshop on this, let me know. I'm always listening, and I'll see what I can do. Thank you, Karin, and have a good night.
Take care.
Bye.